Hey y'all, it's your legal bestie attorney Simone, and I am live outside of the courthouse at the Diddy trial. So come on in here and let me give you a quick little update. It's late, and they are still going at it in there, okay? Me and my brazier, it's over for us. I got to go home, take that bad boy off. I'm about to throw it on the floor and step over it, okay? Have me a little glass of wine, but I'm going to give you a quick little wrap up. The talk of the day is how the feds are dropping charges. I did an earlier video. If you didn't get to see it earlier today, they're not dropping anything. What's going on is they're streamlining what proof they want to present to the jury. And what they stated earlier today in a letter is that as it relates to kidnapping and arson, they're not going to focus on the attempts. Now, when we got up there, they submitted that letter last night. When we got up there were additional arguments. They also said for the S trafficking regarding the aiding and abetting, that they're not going to focus on the aiding and abetting of the S trafficking. Okay? So we get up there and there's just a plethora of discussions. At the time that I was up there, they started with bribery is what I focused on. Okay, so bribery, with the bribery, they were asking for an instruction that would have made a big difference. So remember, I've been saying regarding RICO, bribery would be one of the easier charges to prove. Why? Bribery is not about the acceptance, it's about offering. Well, the defense wanted added to the jury instructions the fact that the government needed to show that there was an ongoing investigation or even an intent that there be an ongoing investigation in order for there to be a bribery. And the judge said, no, that's not necessary. I made a little note here. This has been going on for hours, guys. It started around 2 o'clock. I made a note. It says there ain't enough Adderall in Harris County. That's where I live back home in Houston. There ain't enough Adderall in Harris County to make me want to sit through the rest of this ish, okay? Ain't enough Adderall in Manhattan County. Okay, he's over here laughing at me. It ain't. It's not enough. I gotta go. Lucky for me, I had a little beverage in my work purse. You ain't had one of these beatboxes? Bye-bye. I'm not drunk, I'm tipsy. Just kidding. Oh, it was some word salad shenanigans. If you've ever played Taboo with a group of lawyers, I did that in law school. You don't ever want to do that, okay? I've done that. That's what this felt like. Playing Taboo. Okay, here comes the ambulance. Somebody else is dying today. I'm sorry. It's New York City. The water is terrible, I guess. Come on in here. Come. Oh, my word. It's driving me crazy. I'm going to continue. I was talking about, so they're going back and forth. Let me just be clear. Here's what's happening upstairs. They're fighting word for word, paragraph over paragraph, over what's going to be included in the jury instructions. We start with what's called pattern jury instructions, meaning just template jury instructions. And then each side wants to add something specific that's either going to help or hurt their facts. So that's the argument, because each side is like, well, no, I want to clarify this. And the other side is like, no, that's not going to be fair. So as they were up there, as I mentioned, I said it felt like listening to two different groups of lawyers playing Taboo, where you're arguing about the meaning of words. I've done that before, and I have to tell you, I've had pap smears more exciting than that, okay? I've had pap smears more exciting than what I had to listen to up there. This is going to be a real quick live. It's going to be real quick. And I was ashy. So in the middle of trial, I had to go in there and I had to put some Astroglide on my elbows, on my knees. And it actually does work, by the way. It's just ashy. And now I'm itching. Bugs are biting me. So we're going to hurry this up. So one of the more interesting things was there's an argument about bribery. The defense wanted additional language to say, hey, it can't be bribery unless there is an ongoing investigation or an intent for an investigation. They wanted similar language for tampering with evidence. Well, the judge denied it regarding bribery, but it sounded like for tampering with evidence, he was going to take it into consideration. listen, if he adds the ongoing investigation language for tampering with evidence, Diddy may be found not guilty of that. Why? Because there was special and specific testimony from Cassie, where Cassie stated, where after Diddy paid off, there is a big old garbage truck because it's New York City. Yay, we get all the little sights and sounds. But there was testimony from Diddy, right, where when he was paying off the one hotel worker, he was paying him $100K, and that guy takes the money and then says, well, but if Cassie files a complaint, I'm going to be in big trouble. And Diddy then FaceTimes Cassie and says, oh, no, she's fine. She's going to be happy with this. He FaceTimes Cassie, and the witness says, Cassie then said, yeah, I'm cool with this because I got a movie coming out. So in other words, she didn't want the beating video to come out and interfere with her video coming out. Well, that testimony could absolutely go in favor of Diddy regarding tampering with evidence, because if a juror believes, hey, there was no pending investigation and there wasn't going to be an investigation because Cassie had no intention of calling the police or telling anyone, then he could actually win on that tampering count. And that actually was one of the stronger counts. Let me see some of these comments. It says, girl, I got diagnosed with OCD. It says, no case, time served. Okay, jail, Diddy, jail. Okay, all these different comments. I got it. Okay, then it says, and then the judge was saying, hey, there's no official proceeding requirement regarding bribery. That was true. However, regarding tampering with evidence, if the judge adds the language that there has to be an official proceeding, I could see at least one juror saying, no, Cassie wasn't going to call the police. That means there wasn't an official proceeding at the time and wasn't going to be one. Therefore, not guilty or hung on that charge. There's also, and then it also said, I said, poor Diddy. So Diddy started falling asleep right around 4:10 p.m. Usually trial's over at 4. Diddy started falling asleep. But, I mean, it wasn't like, the jury is not in there, by the way. It's just lawyers and the judge. So he just, he was just nodding off, right? Little salt and pepper, famous hair he has. He was just nodding off. He started falling asleep. He woke up a little bit later, and I wrote a note. Poor Diddy. He could be making jail cell burritos encrusted in hot Cheetos if they just let him go back to his cell. He didn't want to be in there. Didn't nobody want to be in there. That's why I got up out of there. And I'm a lawyer. Okay? I don't want to hear all that. It was annoying. Yes. Okay, so there was a tampering with evidence that was an issue. Oh, and then Mims walked in. If you watch Make It Make Sense, Mims then walked into the courtroom. I made a note. It says Mims walked in smelling like black excellence laced with wire fraud and baby powder. Johnson & Johnson, to be specific. Okay, he came in, chastised on it, and some designer, I think it was Alexander McQueen or something. And it was then at that point that they began to discuss, it was unclear. See, they cite different pages and paragraphs, but we don't get a copy of the proposed instructions. So when they're citing, what happens is there's the proposed jury instructions or the pattern jury instructions that are just generic. And then each side, using track changes, puts in their proposed revisions. But they haven't shared it with the public. So they're simply arguing and citing paragraphs we don't get to see. In doing that, they did get to they called it like 12C or 12B. And related to that charge, it says, we're not going to be charging that. And so the defense was excited. What I'm not clear of is whether that was arson or kidnapping or something else, and whether they were saying they're not going to charge the entire charge of arson, or whether they're not going to charge, as I discussed earlier, the kidnapping, the attempt, the other elements. We could know because they were just talking about paragraphs. They went back and forth, and then as a result, the judge said the judge was going to make amendments. I'm so sorry. I keep itching. I think it's the Astroglide. I didn't have lotion on the train in the cab this morning, so I've been putting Astroglide on my arms and my elbows. Now I'm itching. Maybe it's sweet. I don't know. I've never licked Astroglide, and I don't want to do that today. So they better keep it in there. Yes, hold on. Oh gosh, it says, oh, okay, wait. Thank you, Brittany. We got a super chat. It says, guilty or not guilty. What do I think? I think he's guilty of something. I think he's guilty of something. That he will be found guilty of something. Let me be clear. And because, for example, I don't see how he would get out of the prostitution charge, even with the current. Oh my God, Nita. Oh my God, Nita, thank you so much for this super chat. Nita J. It says, you're awesome and always on point. Thank you for all that you do. Oh my gosh. I got to stop using Astroglide as lotion at this point. $200. You know how much baby oil gel I'm going to buy? Nita, thank you. Okay, let me continue, guys. Oh God, I got excited. That was such a blessing. Thank you, Nita. Sheesh. Good grief. Oh, Idios, Mia. Oh, thank you so much. Okay. Oh my word. Okay, y'all keep them coming. All right, then they got into forced labor. They actually multiple times today, as they're arguing about jury instructions, they referred to the R. Kelly case. And they used it for the claim because in the R. Kelly case, R. Kelly was also charged under RICO for forced labor. And there, the issue was whether certain sexual acts can be considered labor. And the government was actually saying that freak-offs and what Mia experienced, Mia, who alleged S assault, that those could be considered forced labor, and they wanted language added around that. The defense said, no, sexual acts cannot be considered forced labor. It falls outside of the statute, blah, blah, blah. They went back and forth. At the end of the day, the judge is going to make a decision on what's to be included and what's not. Blah, 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 blah. It said objection to knowingly. Oh, yeah, they had objected over a variety of like language. Ooh, y'all. Then we get to the distribution section, right? Distribution of substances. Remember, that's another claim under RICO. Now, regarding that section, the government wanted to add language. The government was like, well, distribution is sharing with friends. So the government wanted to add language to clarify to the jury that distribution is sharing with friends. And the defense said, no, we object. They said it's not necessary. Because what have I been telling y'all? I've been saying, hey, distribution doesn't require sale. And a lot of people in the comments thought, hey, it's not distribution. He wasn't selling the substances. Well, the judge agreed. So the judge was saying, we don't know. He's not going to add the specific language that sharing drugs with friends can be direct evidence of distribution because, quote, they cannot use, that the government cannot use jury instructions to make to make the government's argument for themselves. So the judge is saying, hey, the government can't use these jury instructions to make its argument for itself. In other words, you cannot apply it so specifically to the facts that it's an argument, that it's a given yes. But the judge and the defense acknowledge that distribution is merely sharing substances with friends. Give me a little Molly, give me a little pink powder. I'm your friend. Boom, y'all. That is literally distribution sufficient for RICO. But then the other thing that they wanted, the government wanted, the defense wanted to talk about the fact that, like, hey, you can't find possession just because the substances are found near someone. My Lord, I don't understand why New York has so much goddamn crime. Oh, wait, no, that's an ambulance. Bless their heart. Sorry, guys. All right, so they were going back and forth, and basically you can't argue. They want to be very clear. The defense wants to be clear that, hey, you can't say he was in possession of substances just because the substances were found near him. And then the government objected to that, and the judge was like, no, they're right. You can't do that. And that it says, oh, yeah. And then there was an issue of buyer-seller. So the law is this. The law says there's a buyer-seller like exception to the law, and it says, hey, as much evidence you have, you can't simply say that because Brendan picks up substances from one stop, that alone is distribution. No, picking up something from the pharmacy or a substance dealer is not distribution. And so the defense wanted that to be specified, whereas the government was like, no, we don't need to talk about that. It's irrelevant. I agreed with the defense on that one, because the judge was saying, well, no, we do need to specify that alone is not sufficient, because there have been multiple instances of evidence throughout the case where the evidence that the government solicited or elicited was people picking up substances for Diddy. So the question is, when they picked up those substances, what happened to them next? Where did they go? So what you have to instead show is, like, if Brendan went and picked up the substances, he shared it with Diddy or Jane or Cassie or whoever else. That's what has to be shown. Again, thank you so much, Nita J, for that $200 super chat. I truly appreciate it. Let me see what other comments we got here before we leave. There we go. So as a result, there's a lot of clarification that went on. There was also a whole bunch of nothing. Because ultimately what's going to happen is this. They're still up there right now. It's going to be 7 o'clock at night Eastern time, which means I need to open up my box wine. It's my box wine right here. It's by Beat Box. If you never had one, it's delicious, from Austin, Texas. As you open your box wine, I'm going to say this. Tonight, the actual jury, it's either tonight or tomorrow morning, the actual jury instructions will be finalized, and they should be, we don't know because the court's weird, they should be uploaded to the system. And of course, when I get them, I'm going to go over them with you. But tomorrow, no, is it still on schedule? Hell to the no. As of now, they're not on schedule. And I don't know if they're going to start with opening statements tomorrow as scheduled. If they're not, they're going to notify the jury. But I think that they're actually going to take a dinner break and then try and resume. When I left, y'all check this out. When I left, they were on page 45 of the jury instructions. 45. There's 45 of them bad boys. And they're not done. They were only on like count 2 or 3. There's 5 counts. There's like count 2. I said, I got to get the hell out of here. So when I say this is going to be confusing for this, those jury instructions will be at least 40 pages. So for those thinking, are they going to have a result on Monday or Tuesday? Let me tell you, it's going to take one day to just read those bad boys in the back office, in the jury room. It's going to be a minute. 40 pages. Yes. I'm out of there. I got the heck out of there. Yes. 2 minutes. But the thing is, the more complex the instructions and the verdict form, the more complex the instructions, the more likely it'll be a not guilty, right? Because if people are confused, they're going to be like, oh, I'm confused, reasonable doubt. However, the more specific the jury verdict form is, the more likely there would be a guilty. Because with the specificity, it requires them to really get down and clarify the facts. Let's see what we got here. I'll be happy. Somebody said I'll be happy with 10 years. What is the typical length of jury instructions? Well, for a RICO, they're going to be long. Remember, because RICO has to go through and explain every single one of the underlying predicate offenses. So, for RICO, it's going to be extensive, because what happens in the jury instructions is, for every single one, they have to state, this is the law, these are some of the relevant facts, and then tell you, apply the law to the relevant facts for each underlying, and there's 8 underlying RICO things. Then there's multiple trafficking counts. Yes, hit that subscribe, y'all, hit that like. Oh shoot, my battery's super low. Oh, I got another super chat. Y'all, I'm sorry, I'm sweating like a hoe in church. Thank you for working so hard to keep us updated. Thank you so much. Thank you, Hibiscus Rose. I really appreciate that, y'all. All right, that's all I got for now. I got to go home and take a bath, take my bra, throw it across the room. And I got to teach a class tonight. So, drop your questions below. I'm going to do my best to answer them tomorrow. I'll be up here. The goal is to complete closing arguments by the end of day Friday. So they're going to start opening statements tomorrow at some point. And the goal is to finish them before the weekend. Because what you don't want is to put either side at a disadvantage where either side is in the middle of a closing and then the weekend comes. Because it really messes up with how jurors process that information. So I hope this helps. Good night, y'all. I'm your legal bestie, Attorney Simone, live from the Diddy trial. Bye, y'all. See y'all tomorrow.